Good evening. This comment section is on my video from 11/17/19. Blue Bacon hasn't made a video yet. He's made a lot of comments, so I figured I'd address him. Chargeback normally makes inane and malformed questions to me. Now he's doing it to Bacon. I enjoyed it. If Bacon uses a civil action, I request his analysis of the Toledo Blade case. Why Bacon? Why would the U.S. pay $18,000 to people who actually photographed a military installation? Blue Bacon says I can easily explain that. The judge dismissed the First Amendment claims. The payout was for a violation of the Privacy Protection Act. That is not an explanation. This is an explanation. The defendants were the United States of America, who has sovereign immunity, and then various people acting in their official capacities, which in federal court, they have qualified immunity. There were 10 causes of action. The first cause of action was for the First Amendment. Second cause of action was Fourth Amendment. Then there were 2 causes of action for the Fifth Amendment. The 5th through the 9th cause of action were for state law claims. And the 10th cause of action was for a federal law claim, violation of the First Amendment Privacy Protection Act. So, the state law claims the United States government has complete sovereign immunity to. The First, Fourth, and Fifth Amendment claims the United States of America will only, the courts will only grant you injunctive relief, declaratory or injunctive relief. They will not grant you monetary damage relief. And this is a complaint for damages. So, as far as the United States is concerned, sorry, you're not getting damages. And then finally, these folks in here, they have qualified immunity, which will apply to anything that isn't, to any cause of action or any right that isn't clearly established, isn't clearly defined. And as we all know, 18 U.S.C. 795 is not clearly established or clearly defined in any circuit. So whether or not their actions in enforcing 18 U.S.C. 795 would be in violation of anything is unclear. And so they are obviously and clearly entitled to their qualified immunity defenses. Now, whether or not that went down, I don't know, but I'm going to tell you my version of it, since all I have are the complaint and the settlement. And that's what I believe happened, which is why all of those claims are gone except for the 10th claim. Now, the 10th claim, 42 U.S.C. Section 2000 AA, is kind of a special little monkey. Number one, civil actions by aggrieved persons. You can bring a suit against the United States. And the United States can't assert immunity. Now, there is a good faith defense. It's a complete defense that the officer or employee had a reasonable good faith belief in the lawfulness of his conduct, but the U.S. would have to prove that, which is questionable. I mean, you're going to go in front of a jury. Is the jury going to buy it? You never know. And what it protects against is it protects against the government seizing work product from third persons if that work product is intended to be used to be published in a newspaper, book, broadcast, or etc. Now, these folks who were seized, they were journalists for the Toledo Blade. They were obviously journalists for Toledo Blade, so the government would reasonably believe that these people would be publishing it in the Toledo Blade. Now, there is an exception if there is probable cause to believe that the person possessing the information has committed or is committing the criminal offense to which the materials relate. However, the government's going to have to prove that there's probable cause for 18 U.S.C. 795. And again, the government is not going to be sure that they're going to be able to do that. Now, I believe it'd be the judge who would determine if there was probable cause or not, but I'm not entirely sure on that, so don't quote me. So that's why 42 U.S.C. 2000 AA survives and the others don't, because of qualified immunity and sovereign immunity. Or at least That would be my best guess. I would love to know. I would love to see an order dismissing the other 9 claims 1 through 9, but I can't find it. So I'm telling you what I suspect. Eric the Fathead asked why Freeman's Fort Huachuca arrests charges were dropped. Bacon doesn't know, and I don't know, but Bacon tries to answer it, and I think it's hilarious. The charges were dismissed without prejudice, meaning they can't be refiled. He says, this is something you often see in the prosecution of civilians by the military. Citation needed. He continues, SAUSA doesn't have the time or resources to pursue a lengthy case and will often choose to discontinue a prosecution to focus on other cases. Again, citation needed, and you might want to explain why. But for Freeman filing his motion to dismiss, why the U.S. was ready to go to trial. They were set for trial, or they were headed to a trial-setting conference. One of the two. I mean, it was set to go. Blue Bacon answering another inane question from Chargeback, although this one's pretty good. He says, with regards to 18 U.S.C. 795, what's your solution for dash cams? He has a 360, and he has a 360 installed and records all the time. Blue Bacon says driving by an installation with a dash cam does not reveal enough information to constitute a security risk. There is nothing in 18 U.S.C. 795 that refers to security risks. It refers to taking a picture of a military or naval installation or equipment that the president has defined as vital. That's it. The only intent requirement is that you intended to take the picture, and all you have to do is take a picture of it. It doesn't have to reveal a goddamn thing about a goddamn thing. So this is stupid. This isn't in the statute. I don't know where Blue Bacon pulled this from, but it was apparently his ass. He says if you were doing it repeatedly with the intent to gather information on the base, you could be charged. Again, right out of his ass. There is no intent requirement other than the intent to take the picture. If you want to see something with intent requirements, you can just look at 794. And this one, you have to have the intent or reason to believe this to be used to the injury of the United States. 795 doesn't have that. It is a general intent requirement. Did you intend to take the picture? Yes? There you go. Neither Merb nor myself have a smoking gun, but I do have a lot more evidence supporting my side than he does. Well, I have the law supporting my side. And considering that this is a question of law, not of fact, you might want to look towards the law. But I guess maybe that's a reason why I'm an attorney and you're a cop. Cops look for evidence. Attorneys look at the law. Chargeback says, would pointing a webcam at a naval air station be a violation? They have one pointed at this naval air station. Should he call the Navy? Blah, blah, blah. Blue Bacon says, idiotically, that would depend on whether or not the naval installation, he classifies it as an installation, but apparently it is a station. It is a station. It is a station. Was marked, designated, or classified as restricted, confidential, top secret, or secret? Restricted is no longer a classification. You cannot designate something as restricted. The classification of restricted no longer exists. Therefore, nothing will be marked restricted. You're retarded. It is not a security classification. This is related to 10-10104. This was published, or I don't know, signed by the president in 51. Same president that signed 10104 in 50. This goes over. This is the predecessor of 13526. And so there shall be, I think this should be 4, FOUR, categories of classified security information, which in descending order of importance to national security shall carry one of the following designations. So classification that will carry a designation. No other classification or classifications shall be used to designate classified security information. Designate, classified, check, check. What about marking? Marking, the term marking as used herein means the physical act of indicating on classified security information the assigned classified or change therein. Well, you think maybe it doesn't deal with information. Material. The term material is used here and may mean any document, product, or substance on or in which information may be recorded or embodied. So it's a product, and substance. The term product and substance as used herein mean any item of material other than a document from which information may be obtained. Apply to items at all stages of development, processing, or construction, and includes elements, ingredients, components, accessories, fixtures, dies, and models and mock-ups associated with such items. So there you go. I think I have killed that little argument there. But here's the coup de grace. Chargeback says it is. In fact, even the water itself is restricted by a CFR. There's a CFR. Here's the obligatory restricted sign. And there it is. Now what? And crickets, right? Because poor kid doesn't know. Internal Security Act of 1950, Section 21, 50 U.S.C. 797. 50 U.S.C. 797. This is for defense property security regulations. So the sign is actually not referring to the CFR that he posted. The sign is referring to this CFR. And it's for property security regulations. It relates to fire hazards, fire protection, lighting, machinery, ingress, egress, safeguarding against destruction, injury by accident, enemy action, sabotage, or other subversive actions. It is literally about property. This is about property. This is the tool by which the United States can enforce the policies of those base commanders to protect the property in their possession. It doesn't have to deal with classified information. Nothing at all to do with it. But he got all confused because there is this CFR, which does designate this area as a restricted area. But you can tell this is in Title 33. I think Title 32. Title 32 is National Defense. Title 33 is Navigation in Navigable Waters. And you can see this has nothing to do with classification. There's just some other reason, presumably having to do with danger zones that they want to keep people out. I don't know. It doesn't really matter. Anyway, I think I've beat that to a pulp again. Sorry, Blue Bacon, you're just wrong. And I don't know why it's taking you so long to write a script. I mean, this is my third video. My first video I started and completed while you were live streaming. So, come on, dude. Get it together.